Hello, my name is Emily, and I'm here today with nationally recognized authority and trust clause litigation, Dan Dalton. How are you doing today, Dan?
Emily, I'm doing great. The Lions are 8-1. We're on our way to a playoff run, which is super exciting and unexpected and all that. So it's a great day.
It's an exciting time to be in Detroit, that is for sure. So, Dan, you've engaged in numerous discussions with local church leaders across the United States where bishops, district superintendents, and pastors urge them to remain in the United Methodist Church amid the disaffiliation process. The church leaders offered reassurance that opportunities to leave the denomination would arise in 2024, either before the General Conference, afterward, during the jurisdictional and annual conferences, or following the Judicial Conference decision in November of 2024, indicating that no exits would be permitted. Now that the Judicial Council has obstructed all amicable routes for exiting the denomination, local church leaders are shocked, disappointed, and outraged at their conference leadership for offering misleading information. Is there any feasible way for these congregations to move forward?
I'm going to have to give you the lawyer it depends answer, Emily. Uh, we are finding out throughout the United States, it's a similar pattern. A promise was made during 2023 and 2022 to local church leaders that if they would just stay in the denomination, there'd be an easier path out during General Conference of 2024. And a number of churches believe their pastors, bishops, and district superintendents. And then when General Conference came about and they made a decision not to allow disaffiliation, a second promise was made just to hang in there and there would be another path forward out. Promises were made by numerous conferences to do that. And then jurisdictional conferences came out and said no path out. And the same promise was made. And then annual conference meetings occurred and the same promise was made. And then the Judicial Council just ruled in November of this year that there would be no pathway out. And now the annual conferences are saying there's no pathway out. And so, yeah, it's very disappointing for these local churches. They're shocked. They're shocked that they were lied to. And yes, they were lied to. They're shocked that they were misled. Yes, they were misled. They're shocked that their bishops and their district superintendents would lead them down this path where there's no amicable pathway out. And so they're looking for what other options they have. And there's really three options any local church has right now. The first option is to stay in the United Methodist denomination. Um, it's not a great option, but it is an option because, quite frankly, if you just stay in the denomination and you stay off the radar of your annual conference, probably nothing's going to happen to the local church for the next couple of years. There's so much going on in these conferences right now that there's just not the bandwidth to cover all issues. A number of smaller churches, for example, with older congregations that don't really want to fight or don't have the financial capability to fight are just staying in and waiting for the church to kind of die out. And that's what they're going to do. And that's okay. And if they want to do that, they can certainly do that. But that's one option. A second option is to walk away. And we're seeing more and more churches take this option. And that it's the path of least resistance. They're in good conscience. This congregation can't stay in the United Methodist denomination. They don't believe that in their leadership, whether it's a pastor, or a district superintendent, or a bishop, and they just feel like, you know what, I really don't want to fight this anymore. And so they're walking away. And we're seeing a lot of that happening, you know, especially in states where the state law is very difficult for these local churches. The third pathway is litigation. And litigation is possible in some states. If you go back to our early videos and blogs that we've written, you'll see there's a lot of discussion among in those resources about the state law and the importance of state law in determining religious property disputes. So, real briefly, back in 1979, the United States Supreme Court decided a case versus Jones versus Wolf. And the long of the short of it of that case is the Supreme Court told local state courts you can make a decision how you're going to adjudicate religious property disputes. You can do hierarchical deference, or you can do neutral principles of law, or you can do a mix of the two. And so a number of states just made their decisions how they're going to move forward after Jones versus Wolf. There are some states where they leaned hard into hierarchical deference, and even the bishops and conference leadership went to the state legislatures and had state laws enacted to basically enforce the discipline. You see that in Wisconsin, you've seen it in Maryland, you've seen it in Washington, and to a degree in California, and some other states as well. And really, the whole point of that is that these bishops wanted to make sure that none of their properties could leave without their permission, meaning without paying a king's ransom for the properties. There's other states that have leaned hard into neutral principles of law, and that is looking at your state corporate law. Every church is a corporation, whether you're incorporated or not. You could be an unincorporated association under state law. And as a corporation, you have certain rights and duties and obligations that arise out of the State Corporations Act or out of case law. And with that, you can go ahead and you can apply those corporate laws and case law with respect to the operation, the governance, and the property that you own. And again, Texas is a good example of one state that has leaned hard into neutral principles of law, and local churches have been able to get out. There is a really good case called Masterson that was decided in the 2010s area. There was a case called Salazar decided in the 2015s. And most recently, there was a case called Southern Methodist University that the Court of Appeals decided in Texas, and it's now pending before the Texas Supreme Court. And if the trend line is similar in the Southern Methodist University case as it is in Salazar and Masterson, I think we're going to see the trust clause being invalidated in Texas, and those churches will be able to get out. So the point of this is each state has its own method and mechanisms of giving out. Even if you are in some hierarchical deference states, you can look at your deeds, meaning the title work to your property, and your corporate foundation to see if there's another pathway out. For example, you may be an older church and it's unincorporated, and you might have the property deeds are to the trustees of your local church, where there's no trust clause in there. In those types of cases, it would be a strong inference and argument that the church is locally owned and operated and has no allegiance to the United Methodist Church. That issue is being litigated in Alabama right now in several cases. And it's being litigated in other states as well. But Alabama is kind of leading the charge in those type of cases. So the bottom line, Emily, is not to lose hope. These local churches, what they really should do is take that opportunity to work with us or another firm to find out, based on their current status, what does their article say? What does their bylaws say? What do their deeds say? And then mix that into state law and make a determination as to whether or not there's a path forward. The answer may be no. You know, that might possibly be the answer, but there also may be an answer yes. And so just spending a little money with legal fees and a little time to answer this question might give you a path forward. There's another path forward as well, and that's a fraud claim. Fraud claims are typically tort claims, meaning personal injury type claims, but there's also fraud claims in contract as well. And so these are state law claims, and each state kind of goes through and determines what the fraud, if there's a valuable fraud claim. In a lot of churches right now, like we talked about in August, are looking at that issue in the context of their annual conference. Their bishops, their district superintendents have told them for years there's a pathway out and don't leave during the disaffiliation period. But now they're kind of stuck in, the path forward. In those claims are good, viable claims that you can, that we believe can be asserted to give churches some relief. So each state has, like I said, has its own elements. And let me kind of run through a couple of them for you, just to give you an idea. In Virginia, for example, you have to prove fraud with 6 elements: that there was a false representation of a material fact made intentionally and knowingly with the intent to mislead, the reliance by the local church or the party misled, and damages to the party misled. Fraud requires a couple of things. One is clear and convincing proof. In other words, we can't guess in terms of what that proof is. We have to have that proof before you file suit. And it's that it also requires specific pleading. In other words, in your complaint, you have to specifically say, on this date, this person said this, or this document said that, and that was the fraudulent claim that to kind of go forward. So in Virginia, you have viable claims for fraud. In Tennessee, the same type of situation exists. So Tennessee has the same elements, but they also have claims called fraudulent, constructive fraud in confidential relationships and fraudulent concealments. This is an allegation, in addition to what we talked about before, is that the nature of the relationship which creates a duty to disclose, and a breach of that duty constitutes constructive fraud or fraudulent concealment, and it springs from the confidence and trust reposed by one in another, who by reason of a specific skill, knowledge, training, judgment, or expertise is in a superior position to advise or act on behalf of the party bestowing trust and confidence in him. Once that relationship exists, there exists a duty to speak, and mere silence constitutes fraudulent concealment. So in these type of cases in Tennessee, for example, if a party says, there's a pathway out, and they're, for like a party in confidence, a bishop, district superintendent, a pastor says that, where they know there's no path out, which I believe is they've all known all the way along there was no path out, you would have a viable claim for fraudulent concealment, and it would be a question of fact for a jury to decide that particular issue. And that jury decision case would be in a local county where your property is located as well. So you have that. And then let's look at Georgia. One other claim. Georgia has very similar elements to Virginia. 5 elements: a false representation, knowledge of that the representation being false, intention to induce the plaintiff to act or refrain from acting, justifiable reliance by the plaintiff, and damage to the plaintiff. You have to prove each element by clear and convincing proof, and you have to that when you're challenging these, the challenge is, quote, complete lack of evidence as to one of these elements. In other words, the conference has to show there's no evidence that could exist on these elements. So there are claims, just kind of using the Virginia, Tennessee, Georgia example, that you could assert fraud claims there. Now, having said all that, let me give you a little advice of what we learned during this litigation in the last decade, or actually 2 decades I've been at this, and experiencing these particular cases. One is that your judge that's going to adjudicate this thing really has a lot of control over this case. You may have the facts and you may have the law, but if the judge is not on your side, you're going to lose. There's no possible way to know that until you get into a case. But you just need to know that you might have everything going for you, but the judge may not be on your side. And if the judge isn't on your side and there's really not a lot you can do about that, you're going to lose the case. Conversely, the judge can be on your side. We've had other cases where the proof might be a little bit marginal, but you have a judge on your side and is going to advocate and make decisions, not advocate, but make decisions that is more helpful for you to get through to that point where you need to be at the end of the day. The judge is really going to be the tipping point for you. So knowing that going into the case, if you're in a county, you have a favorable judge, for example, it might be a good thing to do. If you're in a county where your judge is a trustee in a United Methodist Church, for example, or family member is active and involved in United Methodist Church, or a spouse is active and involved, probably going to lose. We've experienced that. So those are types of things to consider moving forward. But at the end of the day, it's for the local church to decide, and the local church leaders have to decide Can they live in this denomination or not? And if they can't live in the denomination and they don't want to walk away and they want to fight for their property, they need to be in it for the long term. And it's a tough decision to make. And again, we've been working with lots of churches, and I can help you kind of have that dialogue, because this litigation is not for everybody. It's expensive, it's unpredictable, it's tough. But in a lot of cases, you can be successful moving forward. So that's kind of the message I'd like to leave with you today. There is hope. We just have to do the groundwork to find a path forward for you. And that path forward is likely going to be litigation.
Well, as always, thank you for your insight, Dan. If your church is interested in setting up a consultation with Dan, please reach out to our office at 313-859-6000 or email us today. Thank you.